All right. It's not often we get to say this, but good evening. Welcome to Ask the Attorneys, co-hosted with our gracious partners for this, our gracious co-host for this evening, the city of Tamarack. If we have Carolyn join us from the city in a couple of moments, we will, of course, give her the floor to welcome everybody and say a few words. But if not, we've got you covered. Today, you guys are the ones who came up with the topics for this evening's discussion. So during registration, most of you filled out the form field number 10, where you asked us some questions to cover for this evening. We're going to go through ones that we deemed appropriate and not too specific. We're not going to get to all of them. We had a ton submitted. We're going to get to as many as we can in the next hour or so. My name is Jeff Solomon from Kaye Bender Rembaum, and before we get started with the actual Q&A, I want to introduce one of the very few board certified specialists in condominium and plan development law from our Pompano Beach location of Kaye Bender Rembaum. This is Andrew Black. Andy, say hi to everybody.
Thank you so much, Jeff, and good evening to everyone out there. I know I speak on behalf of the firm. We are very appreciative and grateful. I always say you could be anywhere in the world right now, but you chose to spend some time with us. So I want to thank you, and hopefully you will learn a thing or two.
Yeah, we've got some great questions today. And before I get to the first few questions, just want to remind everybody, I know there's a lot of confusion about board member education, and I know there were even a few questions about that, which I'll address right now because this part doesn't require an attorney's answer. There are no CE credits for managers with this session. This is strictly informational. There is no board member certification with this session, no continuing education for board members. This is strictly something that we like to do a couple of times a year because there are always a lot of overlapping questions we don't get to with our sessions that cover certifications and CEUs. So tonight is that night where we're going to go through a bunch of questions that you, our wonderful audience, has submitted. So Andrew, you ready for that first one?
Let's go. Let's start.
Sounds good. And we will not name names, so we're not going to read people's names. We're just going to do the question. So the first one that we have here is, what authority does the president of a board have over the board members? So it's, I guess, the president and maybe even a couple of officers. What kind of power do they have over the other board members?
Yeah, that's a great question to start us off. We get variations of this question a lot.
Yeah.
And sometimes owners and managers and boards have to deal with perhaps a rogue member of the board trying to bind the corporation without proper authority.
Nah, that never happened.
Yeah, right. Exactly. And I think there's a misconception out there that just because you have a certain officer role, like the president, that you get some special authority or special power. And in reality, every member of the board, whether you're the president, vice president, treasurer, whatever your officer hat that you wear, you still get one vote. You know, when an item comes before the board, each board member gets one vote. Okay. And that's for any formal policy that's approved, any vendor that's being hired, any contractual agreement that's being approved. Each board member gets one vote. So while the president is thought of like the CEO of the corporation, he or she doesn't get to bind the association simply because they have that role. Now, what I see lots of times is a majority of the board will previously approve assigning certain binding authority to one member of the board. And oftentimes that is the president. And one sort of last final important point is that the officers, they are elected by the board members themselves, right? The owners elect the members of the board. Once that board is elected, then those members of the board, usually at the organizational meeting following the election, the board members themselves vote to appoint who fills what officer role. So whoever asked that question out there, if the president, if he or she is not doing a good job in the eyes of the other members of the board, those board members have the right to appoint someone new to serve in that president role.
Makes a lot of sense, and you explain that very well. Um, the next one, let's see, we're going to change the names to protect the innocent here. So, I'm very interested in the proper procedure for waiving reserves in 2025. My association did not mail out the proposed and alternate budgets. It seems the board believes they can approve waiving without a majority vote of the shareholders. Is that accurate?
Okay, so the answer is no, that wouldn't be an accurate statement. In order to waive reserves, and we're really talking about most of the time in a condominium association setting,
Right.
condos governed under Chapter 718 of the Florida statutes. I believe they use the word shareholders as well, and that
Right.
may be referring to
Owners?
a co-op that's governed under Chapter 719 of the
Hmm.
Florida statutes. It's relatively rare for a homeowner association governed under Chapter 720 to deal with what's called statutory reserves.
Yeah.
So, presuming this is a condominium association governed under 718, the board on its own does not have the authority to do anything other than fully fund those statutory reserves.
Yeah.
So whether the board wants to partially fund those statutory reserve items or even entirely waive the funding of those statutory reserve items for that year, you need to seek the approval of a majority of all unit owners. So 50% plus one. It used to be a majority of the quorum that was present. That was
Hmm.
changed. Now it's a majority of all owners. So that question whether to waive reserves does need to be presented to the unit owners. And a little caveat to that: if you're in a condo that's 3 stories or taller, I know everyone's probably tired of hearing about CEUs and non-CEUs and milestone inspections, but if you're a condo association that is 3 stories or taller, your opportunity to even allow the owners the ability to vote to either waive or partially fund those CERS reserves, those structural reserve items,
Yeah.
that ends on December 31st, 2024. So if
Well,
you don't get that majority owner approval to either waive or partially fund those CERS items by the end of this year, the annual budget for 2025 must have fully funded CERS. And any annual budget adopted after December 31st, 2024, you no longer even have the ability for owners to vote on that, and you would need the fully funded CERS. So, yeah, and I think it's a good, I sort of forget personally to do my little attorney spiel. Usually I wait to the very end of it. So I think it's a good moment just to keep in mind out there what our goal is for tonight is to give you all good general educational information, whether you're on the board, you're a manager, you're thinking about running for the board. This obviously should not be construed as specific legal advice for your community. So it wouldn't be an accurate statement for you to go back to your other fellow board members and say, I met with an attorney, we can do X, Y, or Z. Really, if you have a fact specific question, make sure you contact your association's attorney. That's what we're here for, to hopefully keep you all out of trouble and in compliance with the Florida statutes.
very well said. And the same can go for any of the recordings of our huge library on the website where we have a lot of our past courses. Just
Yep.
note that, just like tonight, that is strictly for informational purposes only. Here's an interesting one here. Well, they're all interesting, but this one, should the condo board post the contracts and bids on the website rather than just a list? So I guess what the person is asking is if the contracts are listed with the
Yeah,
validity dates. Do they also have to provide a link to them so that the owners can open them up and view what they are?
right.
It just
So
be a list.
got it. So the question should, in the eyes of the law, doesn't mean must, right? Just
Right.
like may and shall.
Yeah.
Those are very important words. So I guess the best way to answer that is the way the law reads now for a condominium. Um, you only are required to have a website if you have 150 or more units. And if you do right now, you need to have a website. And the way the statute reads is you only need to post a summary of what contracts you have. It doesn't need to be the actual contracts themselves. The statute was changed, I believe, effective January 1, 2026. If you're a condo that has 25 or more units, you're going to need that website as well. So if you're less than 150, you only have a year or so before your statutory obligation to have a website is triggered. But again, you're only required to just post a summary, right? Just
Yeah.
a you don't need to post the actual contractual agreements themselves. Should you post them? That's entirely up to the board. It's really within the board's reasonable judgment to do so. Obviously, if an owner makes a request to inspect those contracts, they have the right to
Yeah.
physically see them.
Right.
Whether you want to make
Certainly
it
a transparent way of doing things.
absolutely, and if you want to make it easier for them just to hop on the website, you can. In a homeowner association context, you'll need a website if you're 100 or more homes, and the same analysis applies. Should you post the actual contracts? You certainly can. You're not required to. It would be up to that respective board whether to do so.
Okay. That's going to take us to a violations question. And they even this person who shall not be named even gave us an example. So, can a continuing violation be month to month? And the example is, for example, somebody parks a car on the grass for 30 days in the month of May, plus $1,000, then parks on the grass 20 days in the month of June for another $1,000. The paperwork was done new and the board voted on it new, et cetera, et cetera. So how does it, can they go month to month, or is it a one-time thing? How does that work typically?
Yeah, so it's kind of an interesting fact pattern. The way the statute reads is the maximum fine amount is $100 per day, up to $1,000 for a continuing infraction. There's a little caveat for a homeowners association. You can have higher amounts
Hmm.
in an HOA if your governing documents expressly provide for higher sums. But let's just go on that $100 a day up to $1,000 for a continuing infraction. Attorneys hate math, but to me, that's
So do
10
I, and I'm
days,
not an
right?
attorney.
Right. So the $1,000 question is, well, if someone moves their car from the grass to their driveway,
Yeah.
is that violation cured and you start the clock all over again? In theory, you could go into infinity with that.
Yeah.
I think that's somewhat of an aggressive approach, although I'm not aware of any binding case law in Florida that has ruled on that specific fact pattern, that type of infraction that really gets cured every time the car goes off of the grass. If you take it to the most absurd thought process, as soon as the wheels leave the grass, it's cured and they pull right back on. So I think we get into a little bit of the weeds with these types of things. My view is perhaps it's a more conservative approach, but if you want to avoid any type of challenge, I think it's best to cap it at the $1,000. And I think it's important for boards to know fining is just one enforcement tool that's out there, right?
Ooh, what are some others?
Exactly. It doesn't cure the underlying infraction. If someone has big bucks, they might just write a check and say, here's the $1,000. I'm going to keep my car here. I'm going to keep the boat here, right?
It's cheaper than where I live up north. Why not?
Exactly. Exactly. So in that case, the board really needs to think about getting their association counsel involved,
Yeah.
perhaps to start a covenant enforcement action where, and there's an initial demand letter is sent from the law firm requiring compliance within a certain number of days. If the owner doesn't comply after that, the statutes, and this is for both 718 and 720 for condos and HOAs both, it allows an association to actually file formal legal action against the homeowner. Obviously, that's the last resort, and we certainly encourage exploring and exhausting all other amicable ways to cure things. But just know you do have the ability to file ultimately a lawsuit against that owner to hopefully get a court order forcing that owner to remove that car, or forcing the owner to take whatever action you want them to.
Okay. All right, now looks like we're moving over to an HOA question. And when I say HOA, folks, there's a lot of still confusion out there because the acronym HOA is so loosely used. It's like, even if you live in a condo, I hear people saying, what's your HOA cost a month? So when we tonight and anytime we do anything online or with classes in general, when we say HOA, we mean homeowners association covered by 720, not a condominium. So this is an HOA question. So a Florida HOA, original declaration of covenant extinguished by the MRTA, which is the Marketable Record Title Act, after 30 years. All lots, is it all lots in the community? How is the revitalization process? How does that go?
Got it. So this is a pretty
involved
question, but I think it's an important question because I want to, if I will be so bold, to give a homework assignment to every board member who's on their HOA board that's governed under 720, or if you're a manager who manages a homeowner association, and your homework is, how old are your governing documents? Because under the law, and it's chapter 712, it's a very convoluted law, but what it essentially states is those recorded governing the documents in a homeowner association, they expire after 30 years. Okay. And it's generally viewed on when the original deck was recorded. There's a more involved process where you do a lot by lot analysis when each home was built. But the good rule of thumb is 30 years from when your governing documents were recorded. And there's a very simple process that to preserve the restrictions every 30 years. It's done by a board vote. You just have a board meeting, get with your association's attorney, obviously, but it's just a bunch of paperwork that needs to be drafted up and signed and recorded in the county, and that will preserve the what your governing documents say. It's got to be done every 30 years. The issue is, and I think this is what this question is hitting, is if for some reason your HOA did not timely do the Marketable Record Title Act preservation process, and it's been 30 years.
Yeah.
The potentially significant problem is an owner could make a very compelling argument that those covenants that bind his or her lot, they have expired. And with expired recorded covenants, the problem is now what's forcing that owner to pay their assessments, right? Without the covenants binding that, an owner could say, I don't have any obligation to pay my assessments. I can paint my house hot pink and you can't do anything about it. There is a process to revitalize them after they've expired. It does require the approval of a majority of all of the homeowners, and it's a very involved process. There's a recording with the state of Florida that has to be done. I can assure you, you don't want to go through the process to revitalize expired governing documents. It's labor intensive. It can be, time consuming, not to mention the cost involved. So the homework assignment is, if you're on a board of a HOA, confirm how old your governing documents are. And if they're more than 30 years, confirm that you've already done the Marketable Record Title Act preservation process.
Good advice. Well, good tidbit. I said
Yes.
we weren't going to use the word advice
I
today.
know it's tough though. Yeah.
Good tidbit of information there. Now this question is more of a phrase, but I want to address it. I want you to address it because so many people
Sure.
confuse the R&Rs with every other document in the association. So
Right.
the phrase, the question or comment that the person wrote is from A to Z special assessments, rules and regulations. So I'm not quite sure exactly what they're asking, but
Sure. I mean, I took it like, well, the question looks like one of two parts. I think one of the questions was maybe the process for a special assessment, what that means,
what
and
they
what
need to do.
what the adoption process is.
Okay.
There's really no such thing as special assessment rules. Rules and regulations are almost always restrictions that the board adopts that cannot conflict with your other recorded governing documents, right? It's really rules are like no glass at the pool. It really should be more housekeeping things. But going back to the special assessment process, because that's a sort of a phrase no owner or board wants to see.
The dirty word.
Dirty word. I think there's just a big article in the Miami Herald this week. It seems like every other week there's some news article that kind of has this very flashy headline about the amount that some condo somewhere adopted for their special assessment.
Yeah.
All a special assessment really is when an association does not have adequate operating funds to pay for something that has to be done. You have an unanticipated expense or some other, bona fide item that you simply don't have operating funds for.
Yeah.
And if you have statutory reserves, especially if you're a condominium, those reserve funds are restricted for what the reserve item is. And you can't dip into those reserves for some alternative use unless you get an owner vote. So oftentimes the board is left with, well, how do we pay for this thing that isn't a reserve item? And quite honestly, oftentimes the only answer is to levy a special assessment. And, there needs to be a meeting of the board where notice is mailed and posted 14 days prior. It's not a regular 48-hour notice. It's a notice 14-day mailed and posted. And the notice under the statute must specifically state that a special assessment will be on the agenda. It must list what the approximate amount is of the special assessment and the reasons for the special assessment. What projects or what item is it for? And, that's ultimately what a special assessment, that's what the process is. We certainly advise our clients before they send that 14-day notice out to the owners. It's probably a good idea. Have your attorney just review it to make sure all the T's are crossed, everything looks right. Because the issue is, if you have a improperly adopted special assessment and an owner does not timely pay, right? Because the board at that board meeting, the board will approve what the repayment options are, right? Whether it's a lump sum or it's an installment payments. And if you have an improperly adopted special assessment and an owner does not pay, your attorney may not be able to go forward with formal collection and foreclosure, right? Because there's fair debt collection laws that are very serious and they need to be followed. So definitely, if you're a board thinking about a special assessment, we advise getting with your association attorney. But if it is properly adopted, okay, the board has the proper authority. They do it at the 14-day notice board meeting. The board adopts it. The minutes of the meeting reflect it was adopted. You then send notice out to the owners, letting them know this is what's been adopted. This is what your payment obligations are. It's treated just like any other regular assessment.
Yeah.
And if an owner doesn't pay on time, ultimately they could be subject to the formal collection, lien, and foreclosure process.
And I also want to note the word assessment is also, it's synonymous with your monthly maintenance payment. So it's the special, that's the dirty word.
Yes,
Arena,
exactly.
not so much the assessment.
Yeah, because owners know, hey, I pay this amount monthly, or some people pay their regular assessments on a quarterly basis, but a special assessment, of course, is something added on top of that.
Right. All right. So now we're going back to a question dealing with contracts. So our prior board president and management company have not been providing signed contracts. What can be done? So I'm guessing that their work is being done and they're not showing requested records.
The signed contracts. Yeah, it's kind of an interesting one. Obviously, if it's the prior board president, I'm assuming he or she's no longer on the board, so they don't really have much obligation as an association representative. But all signed contracts are part of the official records that owners have the statutory entitlement to see, and they can make copies of that. Certainly, there should be a signed contract on file. If for some reason we deal with fact patterns where there's been a transition of management companies, and perhaps some of the official records got lost in that transition process, what I, as a practical tip, I often suggest the boards is contact those vendors directly that you don't have a signed contract on file. They should have their version of it. If it's the management company that doesn't have their signed contract, well, I would be very surprised at that. I mean, they're absolutely should have that signed contract. And at the end of the day, if you really can't get copies of that, you would have to get your association attorney involved.
Yeah. Here's one that is borderline getting specific, but not totally. If a main sewer line is broken in a condo building, so we're talking condo, who is responsible for repairs inside of the homeowner's unit? If it's a 3-foot, here's an example, a 3-foot deep trench is dug to the length of the unit to work on the repair of the building, thus causing, damage to the flooring in the unit.
So I wanted to address this type of questions. I think it's very important for all board members and managers to know. If there's ever a question about the general day-to-day maintenance and repair obligation, who fixes what? That's what I call a document-specific thing, where you would actually need to have your association counsel review what your governing documents provide for that. And I've never seen a set of governing documents that does not have some sort of maintenance provision in there. Oftentimes, it's not as artfully drafted as we would like to see, and it can lead to more questions than it does clear, concise explanations. But who fixes what? That's a document-specific thing. What this question a little bit is dealing with is a concept called incidental damage to a unit. Which is where, let's just say, the underlying portion of the property that needs to be fixed, it's common element property that the association is on the hook for. There's really not a question about that. The question is, in order for the association contractor to have sufficient access to that common element property, they need to cut through the tile flooring of the condo unit. So that begs the question, who's responsible for that cutting through of that tile flooring? That's what is commonly called incidental damage, right? It's
Right.
incidental, it's ancillary to the main common element work that's being done. And the answer to that is who's responsible for incidental damage? It's document specific. We've seen lots of governing documents that hold
Wow.
the association responsible for that incidental damage. There's other documents that do not hold the association responsible for that
Yeah.
incidental damage. In my view, if the documents do not clearly make the association responsible for the incidental damage,
Yeah.
in my view, the owner is on the hook for that. And it may be
Hmm.
counterintuitive saying, hey, I didn't do anything wrong. Why am I paying for you having to cut through my property? Well, the answer is, unfortunately, when you live in a condominium, you're living with, you own a pro rata share of that common element
Yeah.
property. And if it has to be fixed, part of the bargain of living in a condominium is there may be a fact pattern where your individual property may have to be accessed in order for the association to fix what they have to fix. Now, if the association acted in an unreasonable fashion and never maintained the common element property, which led to them having to do this work, then
Yeah.
certainly that could give the owner more of an opportunity to aggressively argue that the association is responsible since they failed to timely address the problem. But if the association didn't do anything wrong, they're just timely having to fix what is broken. If the documents don't require that incidental damage to be paid for by the
Hmm.
association, then that, in my view, would fall to the individual unit owner.
Good questions to ask before you buy somewhere, before you sign
Yes.
that real estate contract.
Yes.
Um, Earlier you might have seen me smirking, and I was smirking because I'm about the question I'm about to read. I've actually faced stuff like this before when I was out in the field. If our rules say no children, can the board just ignore it and let children be present?
Yeah, this is kind of a sort of a interesting question.
Yeah.
The law is really, I find it a fascinating thing because you always
Yeah.
have the law and then there's exceptions to that. And oftentimes there's exceptions to those
To the exceptions.
exceptions. So the big premise is certainly no association can engage in what's called housing discrimination, right?
Yeah.
Which is you can't reject someone from buying or someone who wants to rent based on a constitutionally protected class,
Yeah.
national origin, race, gender, all the things we hopefully know. One of them is the age, right? You can't turn someone down because of their age. However, the exception to this is there are what's called housing for older person communities, 55 and up.
Right.
Exactly right. That is the only what I call legal housing discrimination, where an association could actually reject someone from residing in a home due to how old they are. Now, it's not as simple as the board just adopting a rule saying we're housing for older persons. No, your governing documents need to provide for that. It can't just be a board rule. But if your documents provide that you are a housing for older persons community, what that means is to maintain that status. There's something called the 80-20 rule, which people have probably heard of.
There's math again. Come on
There's
now.
math. I know. I know. I promised we wouldn't do a whole
Come on,
math.
man.
But what that means is 80% of the homes must have at least one occupant who's 55 or older. Okay. And if your documents properly have you as a housing for older persons and you enforce that 80-20 rule, you can absolutely prevent minors, right? Under the age of 18. You
Yeah.
absolutely can prevent that. What I want to point out, because there's a common misconception out there, is that for housing for older person calculations, it's the age of the occupants that matter, not who's on the deed as an owner.
An owner.
You can be any age on the deed. You cannot
Okay.
turn someone down from being the record owner based on their age. It's
Okay.
only if they intend to occupy that home. That's when the age for those housing for older person communities comes into play.
That makes sense because we may want to buy something now for when we retire.
Absolutely. And no board could prevent you if you simply are the record owner and you're under that age, but don't intend on
Yeah.
residing there.
Okay. Because this next one is about collections, but it looks like it's about reporting. So, what is an association's responsibility with the collection, maintenance, and reporting of monthly maintenance fees from residents? Do county, state, or federal housing policies require detailed record keeping of these fees and notifications to residents?
Sure. So it's kind of a multi-layered question.
Hmm.
The simplest answer is the accounting ledgers of every owner, payments made, that's part of the official records of the association
Yeah.
that must be kept on file. And it's actually not private. If an owner wants to see the accounting ledgers of other owners, you have to make those
They can.
available. Yeah. Now, there's no reporting requirement. A board doesn't submit the payment history to any, federal or state or county office, but it's just maintained in their official records that owners have access rights to. Certainly, if delinquent owners are a problem, owners not paying on time, obviously that can become a pretty significant problem because who has to make up that shortfall? The other owners who are paying on time, right? If
Yeah.
owners stop paying. So if you have a collection issue in your community, it's probably a good idea to review what your collection policy is.
Yeah.
And perhaps it might be time to get your attorney involved to assist in that collection process.
Okay. So this next one toes the line, and I guess we're going to interpret it as a well. Let me ask it's a
Sure.
twofold question, and then I may throw a little caveat into there because of my prior experience on the field there for you. As a board member, can you also have a paid position within the association? And
Got it.
now the little caveat is what is that paid position? Is it something providing services to the residents like teaching a class, or is it something that involves official association business? Like what do
Yeah,
they
I'll
mean by
actually take
position?
it three ways because you actually brought up a pretty good point. So the
Okay.
first fact pattern is, can you be paid just for your service on the board, right?
Yeah.
I'm on the board. We always joke the pay is not very good at $0. But what a lot of board members don't know is that the Florida statutes, it's both in condos in 718 and for HOAs in 720. It actually says unless the bylaws say something else,
Okay.
you can't be paid just for serving on the board.
Okay.
So what that means is, in theory, not in theory, in reality,
Reality.
you're right. Your bylaws can authorize compensation for serving on the board. I can't recall any board that we've worked with where even if the bylaws allowed for compensation, that they actually paid their members.
Hmm.
I joke with boards, some board members, they find buried in their bylaws that were recorded, 40 years ago, that board members can be paid. They've never been paid in the history. I say, well, the legal answer is you can because the bylaws authorize it. So you need
Yeah.
to approve that compensation at a duly noticed meeting of the board. I can't imagine what reaction from the owners would be, right? And whether you would stay in office very long if you all voted to pay yourselves. But that's fact pattern one. If your bylaws allow it, actually board members can be paid just from serving.
Yeah.
The more common fact pattern is can the board enter into a contractual or financial relationship with a company that's owned by a member of the board or owned by a family member of the board,
like a roofer
a
or
roofer, exactly.
Pool
Let's say
maintenance, whatever. Yeah.
exactly. Let's say the board treasurer, John Smith, also owns John Smith's landscaping, and they're a
Okay.
perfectly, reputable landscaping firm. There's a common misconception out there, which
Yeah.
you've heard me use that phrase a lot because there's lots of that. But
No, no,
the
everything's crystal clear. Come on.
exactly the law doesn't actually expressly prohibit a board from entering into a contract with John's landscaping just because John's on the board.
Yeah.
What the law says is that is a conflict of interest, but it still can go forward if several disclosure requirements are met.
Okay.
Where John Smith at a board meeting discloses that, hey, I'm the owner of John's landscaping, so that financial interest is known and the minutes of the board meeting reflect that. John Smith has to abstain from voting on that. He can't even be in the room when the other board members are voting on it. You need 2/3 of the board needs to approve that contract. The terms have to be fair and reasonable. So there's various disclosure requirements. Most of the clients that I deal with, they don't even want to go near that fact pattern. They just don't even want to do
Right.
it. Any whiff or appearance of something not on the up and up, they would prefer not even to engage with that. And in my opinion, that's a perfectly acceptable mindset. There isn't anything wrong with that, but it would not be accurate to say the law strictly prohibits that because it's
Right.
not true. You
Right.
can go forward with it as long as the statutory disclosure requirements are met.
Okay.
The third one is, can an owner pay a board member? Let's say the board member is a trainer. I'm just using kind of a
That's
funny,
perfect example. They have a
right?
gym and they want to do personal training, or a pottery room and they
A
want to teach
pottery room.
pottery.
And the board member happens, the law doesn't address whether an owner can pay that board member because there's no use of association funds, right?
Right.
The only issue with the conflict of interest disclosure requirements is when the association is the party entering into that relationship because you're using the association funds. If
What
it's
about
just an
what about
owner,
you?
it's not
Sorry,
the owner paying funds. Yeah.
well, sorry to interrupt,
Yeah, of
but
course.
just along what you just said, what if it's like within an association facility though? Because everybody who lives in the association is paying for the maintenance of that facility, like the gym or the pottery room. They're paying the electricity through their monthly assessments
Right.
or what have you. Does that factor into any of that?
Yeah, I don't think it would prohibit that.
Okay.
I'm not saying it's a great idea. I mean, you want
Yeah.
to make sure there's insurance coverage and all that stuff, but there's nothing in the statute that prohibits. I'll give a perfect example.
Okay.
I have lots of board members that are real estate agents, right?
Right.
And an owner wants to use the board member to sell his or her house.
Okay.
There's nothing in the statute that would prohibit that. I get what you're saying here. The board members using the common areas, but if it's open to other outside trainers, I'm not saying he should be the only one allowed to use it, but if
Right.
it's open to outside trainers and other third parties can, teach the pottery class or other third parties can do whatever, as long as it's not the association using the association funds, the association isn't entering into that contract. There is no express conflict of interest disclosure requirements.
Got it. I'm sorry about that interruption.
That's
You
good.
spawned a thought.
These are interesting fact patterns,
Yeah.
and it kind of spawns off different lines of thought.
And the same. All right. So now that the second part of that person's question is, what about a homeowner? Can not a board member? Now we're talking homeowners. Is it all pretty similar?
Yeah. So there's no conflict of interest disclosure requirements. If a homeowner who's not on the board owns, it's Sue Jones, and she owns Sue Jones Landscaping Company, there's nothing at all that the statute addresses that would in any way prohibit, and there's no additional conflict of interest requirements. The association can hire a company that's owned by just a homeowner. Happens all of the time.
Yeah. Okay, so you addressed this one a little bit earlier, particularly with HOAs, but best strategies for revising 50-plus-year-old documents.
Right.
Declaration first to be consistent with current statutes, of course.
Yeah, I mean, we get asked this a lot. I mean, obviously governing documents, if they're old, they're very well may be lots of outdated provisions in there. Oftentimes we see lots of language dealing the original developer, and that original developer has been gone for a long time.
Yeah.
Or there might even been language that the board wasn't even aware that's there, and the actual practice of the association is something other than what the documents say.
Yeah.
The
Yeah.
statutes change every single year, so sometimes it might be a good idea to incorporate changes to make sure it more accurately reflects current times. So there's lots of reasons why it is a good idea if you've never had your documents reviewed or refreshed to get that process started. There's a bunch of ways to approach it. One way is like a comprehensive document review and amendment process where you can actually have your association counsel review your documents line by line, draft a detailed cover letter back to your board saying, this is what we think should definitely be changed. Here are some things that don't have to be changed, but you may want to change based on what your community desires are, and we'll provide that detailed cover letter. And then the board, or oftentimes there's a document review committee, they'll go through that. They'll say, okay, we love suggestions number 1, 3, 11, 19, 24, whatever the case may be. You then work with your association counsel to draft a brand new, what's called an amended and restated set of governing documents that almost always is voted on by the unit owners. So that's one option. That's a bit more involved process. Option 2 is sometimes the board has already gone through their documents and they just have a list of 3, 4, or 5 things that they definitely know they want changed. It's just outdated. They don't want this. Then you can get with your association's attorney and he or she can just go right to the drafting process to draft those changes. Yeah. And again, it's a document specific thing, but most governing documents require a certain percentage of owners to vote to approve whatever proposed changes there are.
And we have a class just on that topic alone. So check
what
us
a good
out.
segue. Absolutely.
Yeah, check out the calendar. kvrlegal.com. Check out our calendar.
That's great.
Okay, here's one. If a property management company, if your property management company tells you something on the financial records are okay, but it's not correct, you have proof it's not correct, what is the best thing to do?
So it's kind of an interesting question. Obviously, this may be sort of an obvious answer, but I would send the association a letter. I mean, you can send it certified mail outlining what you believe are the factual inaccuracies. And if you're in a condominium, you can ask questions. And if you send it via certified mail, they have to answer those questions. So that might be a good way to sort of hold their feet to the fire, to say, this is what I factually think. Obviously there should be some explanation. If one person's saying the sky is green and you're saying, no, it's blue, it's clearly blue, then there needs to be some sort of clarification there. Ultimately, the property management company is just an authorized agent of the association, right? So I don't know if this person's on the board or not, but you ultimately want to bring your concerns to the entire board and bring them what factual information you have. And the board, in my mind, a reasonable step, if you get presented with information, is to look into it further to get to the bottom of where the truth is, right? Sometimes it's in the middle, oftentimes, but that would be my suggestion on that.
That's a good suggestion. What are the required notification times for meeting agendas to homeowners? But this person did not specify HOA, condo, or
Kind of,
cooperative.
yeah. So I think it's generally speaking, I'll kind of just quickly do both. The first question you always want to ask, because sometimes this notice and meetings can get somewhat complicated if you're new to the board. But the main question to ask is who is voting?
Yeah,
If the owners are voting, it's a meeting of the owners. I mean, that's duh, but you want to think about it like this.
right,
If the board is voting, it's a meeting of the board, right?
right.
So if it's a board meeting, except for a few exceptions, all board meetings just need to be noticed with the agenda posted 48 hours, okay, in advance. If the board meeting is for a special assessment or rules regarding the use of the individual units, that's a board meeting that needs to be mailed and posted 14 days prior.
Yeah,
If it's a meeting of the owners where the owners are voting, you want to check what your governing documents require. You always want to follow that. If your
right.
documents are silent, a meeting of the owners notice is mailed and posted 14 days prior. If it's an annual meeting of a condo under 718, the annual meeting has a first notice that's mailed 60 days prior, and then
Yeah.
a second notice that's mailed between 14 and 34 days prior. So
Okay.
you don't want to screw that up if you're on the board, or obviously if you're a property manager. If you're not sure how much notice is required, it's a very quick phone call to your association attorney. Make sure you get clarity on that, because you don't want to have to do it again. Because what I see happen a lot of times is notice wasn't properly done. They call our firm and somehow they want us to tell them that it's okay. And we have to say, well, you called the attorney. We're going to tell you what the law requires. So our answer is you're going to have to do it over again properly, or you run the risk of an owner challenging what was done.
Just remember, folks, if you try to do more for less now, it can become more of a mess later. So do it right the first time,
Exactly.
you know? Now, this next question, I want to premise it for our newer board members on the event this evening. ARC is an acronym that stands for Architectural Review Committee. So when I use the acronym, I want you to know what it means. So should a board member who is the spouse of an ARC chair, and the ARC committee comes under the direction of the board according to our declaration, okay, in this particular example. So should the board member who is the spouse of an ARC chair recuse himself from ARC decisions and votes? Is this a conflict of interest?
Yeah, I don't see any legal conflict of interest. Lots of people throw that phrase out anytime they see anything
Yeah.
where someone's related to someone or something like that. But no, a conflict of interest, again, really only arises when we're talking about the association, entering into some sort of contractual relationship. Almost always, the governing documents allow the board to appoint who the members of the uh, committee will be. And there's nothing wrong with the board appointing someone to a committee who's a spouse of someone on the board. There isn't any problems with that. Now, a board member or an ARC member shouldn't be voting on their own application. I think it's probably best to
Hmm.
abstain from that. I'm a board member. I want to paint my house a certain color. I don't think you or your spouse probably shouldn't be voting on that specific application. Why even, raise more questions than what it's worth? But the mere fact that
Sure.
a spouse of a board member serving, I don't see any impermissible conflict there.
Okay. This is one that drives me nuts, even with my own family. So you're ready for this
Yes.
one.
Yes.
So can the board of directors send emails to all association members? Now, not BCC'd, meaning not blind copied, but
Oh
CC'd,
no.
carbon copied, where you see everybody's name and
Uh,
email address
that's a
without
whoops.
having email consent from the members. And if not, what can be done to ensure compliance? And like I
I
said, this drives me nuts, even with friends and family.
it drives me nuts too. I mean, the short answer is no, you shouldn't be disclosing owners' emails
Yeah.
unless they've consented to it. So if that happens, it shouldn't happen again. If it happens once, is someone really going to file some sort of action because of that? No. And if you get emails from someone you don't want to get them from, you could just block the sender
Yeah.
email, right? I mean, you're not forced to read emails. But I do want to point out something, that official notice of a meeting can be sent only via email if that owner has specifically consented in writing to receive official notices via email. And if you as an owner have given your express consent to say, dear condo board, I authorize you to use my email address, johnsmith@gmail.com. You can send me official association things. That email address then does become part of the official records that owners get to have access to. That doesn't mean the board should still be CCing it to the whole community, but just know, if you do consent to receive notice via email, your email does become something that is accessible.
Meaning records.
Records, official records. Yes,
got it.
exactly.
Yeah. Got it. Another one that makes me chuckle a little bit. So what can you do with board members who don't want to follow state statutes, and then you are harassed for reminding them of the necessity to do so?
Yeah, this is like the quintessential condo HOA fact pattern, right? I mean,
Yeah.
I always joke, a lot of my job is I play, armchair psychologist, and it's
The referee.
personality management, the whole concept of living with shared walls, if you really think about it, is a pretty wild idea, right?
Yeah.
You're just always going to have personality problems. You just always will. But I wanted to address these types of fact patterns because at the end of the day, the best way to get a change of board is at election time, right?
Yeah.
It happens every year.
Yeah.
You're going to spend a lot of blood, sweat, tears, money, heartache during that term. If they're not listening to you, the best, most effective way is to present to the other owners why you or your slate of people are best suited to serve in that role, and make sure you encourage people to vote. That's the best way at election time. Under the law, the other way is the actual recall process, where you can actually recall and remove a board member from serving. That does require majority of all owners to vote in favor of that. So if you're a larger community, that can be a pretty tall task to get 50% plus one of the owners to agree. There's certain procedural requirements that must be done, but that recall process is a way to get one or more board members off of serving. So, you just want to think about that. Also, if a board member becomes more than 90 days past due in the payment of a monetary obligation, they're automatically removed from service as well. Those are really the most common big three. Of course, a board member can resign, but we're really not talking about that. Those are really the big three to force someone off. If they are quote unquote harassing you, obviously you as an owner have the right to engage your own attorney, and he or she can chat with you whether you actually have any viable causes of action.
Yeah. Andrew, are you a Star Trek fan?
A bit. I'm not a huge one though, so I don't want to let you down if I don't know the.
No, it's okay.
The reference.
Because we need to make a class that Mr. Spock would be really proud of, and it's so perfect about condominium living. And what Mr. Spock would say is the needs of the many outweigh the needs of the few or the one.
Yeah.
And that is a phrase that is on par with condominium living.
Absolutely. Part of the fiduciary duty of the board, which is just a fancy word, it means you're in a position of trust. And so every choice you make, your primary focus should be what's in the best interest of everyone. And oftentimes, not oftentimes, most times, you're not going to please every single person. It's just impossible. And especially in Florida, it's hard to find housing that's not associated with a community association, but you have to know, buying into a condo or a homeowner association, what you're getting yourself into. So,
Yeah. Got time for a couple more?
yeah, we can do a few
A
more. Sure.
few more. All right. So what the recourse, we're talking about recourse for homeowners. So what is the recourse for homeowners when the board of directors is I guess in this person's opinion, wasting its money or entering into contracts that are higher priced or signing long contracts, 6-year contracts, 10-year contracts.
Right.
Now, just remember, folks, this is a non-attorney saying this, that the cheapest thing isn't always the best thing. I just want to throw that out there too, but Andrew, what do you
Yes,
say
you
to that one?
oftentimes get what you pay for. I mean, I've dealt with many boards where they say, Andrew, we're having a vendor problem. The
Yeah.
vendor's not doing what they're doing. I say, okay, send me the contract, and it's a 1-page invoice for 6 figures or more.
Yeah.
And I say, hindsight's 2020. It's up to the board, but we
Yeah.
certainly suggest having your, association counsel review a contract before it's signed. Well, we didn't want to spend the money. We're talking about point percentage points
Yeah.
on a 6-figure contract. To
Yeah.
me, it's money well spent. But this fact pattern kind of follows the last question, is like, a board's not doing what we think they should be doing. And in addition
Right.
to the
Right.
election option, the recall option, perhaps the board members more than 90 days past due, I think it's important, if you show up to the meetings of the board, you always want to act in a very respectful way. Screening doesn't really get much done. But most of the time, if you and fellow like-minded owners participate in a cordial way, but explain what your concerns are, sometimes I've seen the mindset of the board sort of shift to maybe saying, perhaps this isn't the best route, and maybe we should reconsider how we do things. But ultimately, the board is the body that has those contractual right. They have the authority to enter into contracts. We certainly suggest for any service contract, landscaping, pool, management, even, you want to negotiate with to have entered what we call a without cause termination provision. Allows you to get out of the contract because the wind blows a certain way, right? You don't need to prove that the vendor breached. Vendors
Right.
are wonderful people. I've yet to meet a vendor who
Right.
says, you know what, hand up, we breached, we're going to allow you out of this contract. It just doesn't happen, right? So you want to be able to have the ability to just walk away. You need to make sure your contract says that, which is another reason, if you're not sure before you sign anything, if you're not clear on the who, what, where, why, when, how, don't sign it. Get your association attorney involved.
And that's a great point too, because sometimes whatever you're contracting for, it may be technology based, for example, and we all know how quickly technology changes.
Absolutely.
And maybe that particular service provider isn't suited to partake in the new technology, and you want to go that. So yeah, there's so many reasons, so many reasons. What are some of the recourses if the association fails to provide the documentation within 10 days after a request?
Yeah, I believe they're talking about an official record request.
That's how we'll go. Yeah, we'll go that way.
You could contact the state of Florida. There's a state agency. It's a sub-agency of the Department of Business and Professional Regulation. It's the Division of Florida Condominiums, where in theory, they could, hold the association responsible for failing to timely respond to a proper record inspection request. And there's monetary damages out there up to $500. What I will share, which I think it's important to just touch base, an association is not required to cull through its records, find exactly what you're demanding, and just provide you a copy of that. They can if they want to. Oftentimes it's easier, but their only obligation under the statute is just to make the records available in the manner that they're kept. So if you're dealing with an owner who is making repetitive requests, you don't have to find what they want and just hand it to them. You could certainly say, okay, we're going to schedule an appointment for you to come in and inspect the official records.
Yeah, that makes total sense. Here is one that has to do with website posting. Speaking of records, if we have a currently approved lease in a unit, and this person is stating yearly or seasonal, it doesn't matter, must it be posted on our own website or can it remain private for management
Got it.
records only?
Yeah, in my view, the actual lease agreement itself is something that can be kept private and it shouldn't be posted on any association site.
Okay. Now we're moving on to condominiums and reserves. Is the inability to use reserve funds allocated to structural items such as roads and roofs, etc., just for those condos 3 stories or above, or is that a restriction for all condos? And this is, by the way, this example is for a pooled reserves condo association.
Got it. So if it's a statutory reserve item, obviously 3 stories and above has the structural integrity items, but there's non-SERS items as well.
Right.
And if you're a condo less than 3 stories, you still have statutory reserve items that you're required to fully fund each year unless the owners vote to do something other than fully fund, like partially fund or waive. So if you have funds that are a reserve funds, those are restricted to the reserve item only. Now, if you maintain a pooled reserve, you have 3 or 4 reserve items in a single pool, you obviously can use the funds in that reserve pool for any item in that pool. But if you want to use the funds in that pool for something outside of that pool, you cannot do so without an advance owner vote. Okay. Use of statutory reserve funds for an alternative use must be approved by the unit owners. And that's for all condos, no matter what size.
No matter what size. Okay. All right, managers, cover your ears for this one. If the board, if the board decides by email 5-2 to give a new manager of 2 months a significant increase in salary, how might the owners learn about it, and how much about it may the board openly discuss without divulging the actual salary amount?
So there's a couple things I want to point out. First thing is board members are prohibited from voting via email.
Right.
So I'm not naive to think that perhaps that happens from time to time, but the statute says no voting via email. What the statute says is if the board is
maybe they meant e-vote. So
e-vote, yeah, right, exactly. If the board wants to vote on personnel matters, which would involve, hey, we're hiring a manager, or we want to bump up the salary, those personnel decisions can be done at a closed board meeting. So owners don't have the right to attend that, but you still should post notice 48 hours, close board meeting, and the agenda should be dealing with personnel matters.
Right.
If the salary is bumped up, the official records of the association, that salary amount is not private. Owners can actually request to see that. Yep. So that's a lot different. The board's not required to announce at a meeting, good evening, everyone. Our manager is now making this amount of money. They certainly don't need to do that. But whatever record that they have, whether it's the manager contract, another financial record showing what the manager is being paid, that's clearly part of the records that owners do get to see. So there's really 2 things happening. The board really should be voting on those things at a closed board meeting, and owners do get to know that type of how much a manager is being paid.
Okay. And folks, we are going to take a few more questions. I just want to mention that there's an evaluation link in the chat, so please fill that out when you have a chance. And also, when we end the webinar, for those of you who stay to the end, and we thank you if you choose to do so, we hope you do, a when we end the webinar, a browser tab will automatically open up with that same link that we just put into the chat. So there's a couple of different ways you can get that. Okay. So here's the next question is, can a condo, I guess they mean the corporation itself, can a condo
Yeah.
be held liable for any subcontractors or suppliers not paid if they do file a lien 90 days after a project happens to be completed?
Got it. So this is going to be sort of an involved construction lien question, but
Yeah.
I think it's important for boards to know there's Florida statutes. It's chapter 713. It's the construction lien statute that
Yeah.
contractors are protected from being paid by, they have lien rights, and maybe associations aren't aware of that. If you don't pay a contractor, they can secure their interest in being paid by filing a claim of lien against your entire condominium. And if you're a manager or a board who's dealt with that, you know it can be somewhat of a headache because that claim of lien gets recorded in the county. So
Yeah.
every owner that goes to sell, that claim of lien is going to pop up, and that owner's portion of that contractor's claim of lien is going to need to get resolved before that sale can go through. The main takeaway that I want to make sure every board knows, if you have a construction project, you should be requiring as a condition for every partial payment under the contract something that's called a partial payment affidavit, partial release of lien. Sounds fancy. All it is you're having the contractor sign something that says, I'm receiving $20,000 out of this $100,000 project. They will list they have to by law, they will list any subcontractors or suppliers who have not been paid by the general contractor. If they list a subcontractor that has not been paid, you should be inquiring with them, why haven't they been paid, right? And you can even make the subcontractor sign a release as well. And before you make the final payment to the contractor, you absolutely should be requiring the contractor to sign a final payment affidavit, final release of lien. And on that final payment affidavit, the contractor by law has to list any subcontractors that have not been paid in full. And you want to make sure that you inquire what's going on with the payments to that sub. Because what could happen is if they list the subcontractor that has not been paid in full and you pay the general contractor, that subcontractor perhaps could, say, hey, we're still owed these funds. And the worst thing is the association having to pay twice, right? So, it's a little bit of a involved fact pattern, but you want to make sure, if you have a construction project, make sure you're getting with your association's attorney to have the proper partial and final payment affidavits drafted, so you can make sure that you won't be responsible for paying twice for the same work.
Okay, makes sense. This next one revolves around special assessments for hurricane repairs that are in excess of the reserve. So I'm going to read both questions because they're kind of related. So basically the person is asking about the process and when should an attorney services be engaged for it, and then can a condo project use monies from reserve savings to finance, and they have finance in quotes, to finance a repair for which special assessments will be imposed.
Got it. So this goes back to a little bit about the special assessment process. I mean, I think it's up to the board. Obviously, it's the business decision of the board, but I think it's important to get with your attorney before the special assessment notice is mailed. If you have any questions at all, to me, it's just
right the first time.
It's just worth it. As far as using the special assessment money from reserve savings, it's a little bit fact specific. We want to be very careful using reserve funds, certainly for anything that's not for that reserve item, right?
Yeah.
And lots of condos maintain pooled reserves, so perhaps it's for an item within that pool, but you want to make sure there is no such thing as borrowing from the reserves and paying it back. Lots of communities do that, and perhaps no owner has filed a complaint with the state of Florida. But if a complaint is filed, it's
Yeah.
very likely that the state will say that's in violation of the statute. You can't borrow from reserves to use it for an alternative use without getting the owner vote first.
Yeah. So earlier you touched upon what a board can do for owners not paying their regular monthly assessments. All right.
Right.
What about if owners are not paying the full amount of a special assessment? What can a board do?
Yeah, it's the same authority that they have for non-payment of regular assessments. As long as it was properly adopted, they can go through the lien and foreclosure route.
Okay.
Yep.
Okay. Um, are capital contributions allowed when a condo is purchased? And for example, can an association, can they charge $1,000 to a new owner to add to the reserves?
So that's an interesting question. We get asked a lot about capital contributions in a condo context. In our experience, if a complaint is filed with the state of Florida, they'll hold that a capital contribution is improper because they'll consider it a transfer fee in excess of the maximum amount allowed by law. The way 718 reads now is that there can only be $150 transfer fee. So a capital contribution usually is much more than that. It's either a certain number of months of assessments, and I get why boards want it. You want new owners to, contribute right away to perhaps future projects. But in a condo context, in my view, it would be improper for a condo to charge a capital contribution. In a homeowner association context, as long as the governing documents authorize it, in my view, a capital contribution is a valid thing.
Okay. If an SA is approved in a duly noticed meeting using appropriate legal language with a specific project budget and scope, if the scope is modified and the budget is changed, does a new special assessment need to be approved? And by SA, I meant special
Special
assessment.
assessment. Yeah. So the way the law reads is the notice of the meeting, the 14-day notice where the special assessment will be adopted. It's got to say what the purposes are for, and it's got to say what the approximate amount is. Now, in the 14-day time frame, if the amount changes, it's not the end of the world. The board can just adopt the final, the final sum, but the purposes cannot change. And the special assessment funds that you collect have to be used for what the purposes are that the 14-day notice say. So if the amount has changed after the board meeting or the projects have changed, you can't just use the special assessment funds for those other things. You really should be holding a new board meeting to clarify that.
Okay. And I caught myself I've been in this business so long, again, not as an attorney, but I fall into the trap of using acronyms often. So I apologize for that, and I'll try to catch myself.
No, it's fine.
How important is it for a two-story condo association board to commission a period? Now we've beaten 3 stories and higher to death. So this is a question about 2-story. To commission a periodic reserve study to protect itself from negligence claims in the event of a large assessment based on underestimating something like future roofing costs, for example.
Yeah, I mean, I don't think the failure to have one would automatically create a cause of action from an owner. But my feeling is just because you're less than 3 stories, you still have statutory reserve items that you're supposed to fully fund each year unless the owners vote to waive them or partially fund them. And the amount of the reserve contribution is based on what the remaining useful life is. And I don't know how you could know what the remaining useful life is without having a qualified third party professional do a periodic reserve study. So, my suggestion is it's absolutely a good idea to have that done.
Okay. This one comes up quite a bit. So let's do
Sure.
this one here. Who is the enforcer, or what agency, I guess, is the enforcer for the Florida HOA? Well, I see. Hang on a minute. I caught myself here because
Yeah.
we talked about the confusion earlier. So let's do both. So who is the enforcer for HOA laws, and then we'll do it for condos. And what department or regulatory agency actually investigates complaints?
Right. So for homeowner associations governed under 720, except for a very limited fact patterns dealing with recalls and things like that, really the recourse of an owner, you would have to file a lawsuit in state court.
Okay.
There is no state agency out there that's going to investigate homeowner associations.
Yeah,
Obviously, if there's allegations of like criminal conduct,
that's different.
you get law enforcement
Yeah.
involved.
Yeah.
But so if you're an owner in a homeowner association governed under 720, unless it's really an election dispute or a recall, you're really dealing with having to file a lawsuit in state court. If you're in a condominium, it's that division of Florida condominiums. You could just Google search and you'll see it. It's a sub agency within the Florida Department of Business and Professional Regulation. And they have the jurisdiction under the statute to investigate a wide variety of condo fact patterns. And they could certainly assist an owner, with that complaint filing process. And if there is a complaint filed, that state agency has the authority to levy monetary sanctions against a condo. There's all sorts of bad stuff that could happen. So,
Yeah. Yeah. Now, if a board fails to approve a budget for the upcoming fiscal year during a properly noticed and held meeting, can that board adjourn to reconvene later that same day or in another date and time to vote on the same budget again with different board members present?
so that's a very fact specific question. That one you really want to get with your association's attorney. Generally, the board can recess and reconvene. Obviously, the budget needs to be approved by a majority of
Right.
the board. So it kind of seems like there's some game playing perhaps happening with board members not showing up and then showing up. So I think it's best to get with your association counsel on that. What I wanted to point out with this question is,
Yeah.
For an annual budget in a condo, oftentimes there's two meetings on the same day. One's the board meeting to adopt the budget itself. The
Yeah.
other is the owners meeting where perhaps the owners are voting to partially fund or waive reserves. And the owners can cast that vote at the owners meeting via a limited proxy. Those proxies are valid for 90 days. So if you don't have enough owners to establish quorum or you don't have enough owner yes votes for that owners meeting, you can recess and reconvene that meeting up to 90 days from the original date.
Okay. Here's one that comes up a lot, and I'm not surprised to see it on here. And man, I even know the answer to this one. Where can I find the required continuing education class for board members of an HOA?
Well, our firm has them. I don't know if that was the answer you were about to give, Jeff, but the state of Florida, actually, I believe on the Department of Business and Professional Regulation website, they have a list of approved course providers there.
Correct. And the reason I wanted to touch upon
Yeah,
this
of
one,
course.
if I may just take
Yeah,
30 more seconds, because this
Please.
comes up with all of our classes too, folks. The key words to look for are continuing education or certification class. We nor any other provider has yet to receive clarification on continuing education for board members. Okay. So once we know what is going to be approved for continuing education for board members, we will make it explicitly clear in our promotional materials. I just wanted to throw that out there. Okay.
Yeah, sure. Of course.
Thank you for that. And Here's a one. We do have a lot of new CAMs, a lot of new board members. I'm a brand new manager, a brand new CAM. And for those of you who don't know what a CAM is, we're not talking about a tool or a piece of hardware that goes with a screw. We're talking about CAMs, which is a community association manager. What is the best way for me to learn about how to do a budget? What are some good resources that will teach me?
Well, that's a great question. I don't know if this individual is a solo manager, kind of on his or her own.
Yeah.
Obviously, if you work for a management uh, company, certainly tap into the resources available there. I actually think that DBPR, the Department of Business and Professional Regulation, and the Division of Florida Condominiums, which is just a sub agency, they have a lot of educational resources out there. They have various, sort of frequently asked question, those types of things. Obviously, you want to look at what the annual budget was in prior years because it
Yeah.
should be a good faith reflection of what the anticipated expenditures are, and look at all vendor contracts, see if there's any room, to work with those prices for the upcoming year and just work off of that.
Okay. It's 5:25, so we're going to do two more questions. Our proxies, I'm sorry,
I know.
6:25.
I was going to say, oh my goodness, time's moving slow. No,
I'm in this
we,
when I'm not in South Florida, I am in the central
I
time zone,
get it.
folks.
I
So
get it.
are proxies, limited or otherwise, still acceptable for condo association voting? I think they are no longer acceptable in 718, but my property manager disagrees. What would you say is the correct answer?
Well, if you're talking about for elections of the board, there is no proxy voting allowed. So
Okay.
maybe you both are right. For elections, no proxy voting. However, for other owner votes, such as to waive reserves or to amend the governing documents or to, reduce the level of financial reporting or to approve a material alteration, there could be a wide variety of owner votes. And for those other non-election votes, limited proxies are absolutely still allowed.
Okay. Now, our last question for this particular evening is our board of directors was voted in this past March in 2024. We still don't have updated financials posted. And I'm guessing on their website or their records. Their communication to the homeowners is typically via Facebook, which many of us do not use. What kind of recourse do we have?
This sort of ties into the other. The board's not doing what they should be doing. I mean, obviously, if they haven't timely submitted their annual financial report or noticed the owners that one's available, one option is filing a complaint, right, with
Yeah.
the state of Florida. That's one option. The other option is certainly to get a new board involved, right, via
Yeah.
the election process. Certainly, if they have a property manager, perhaps going to the manager as well. I think that could be helpful.
And don't mean to throw you a curveball here, but
Sure.
why do you is social media a good idea as an official association
Yeah, I mean, I'm
tool?
I'm not a big social media guy
Yeah.
at all. I think
Yeah.
anything other than purely factual information,
Like
the
Joe Schmo is performing at the theater Friday night.
exactly, just purely informational, factual. I mean, I don't really have a problem with that. What I see way too often, and everyone knows it, it becomes a sounding board. The owners claim this, and then a board member tries to reply, and then
Yeah.
you have 49 replies, and it really doesn't serve any bona fide association purpose. So my suggestion is anything other than a just like community, factual. We're having a barbecue on Sunday or
Right.
whatever. Anything outside of that, I think really social media is not the best avenue for.
Well, we got one done, Andrew. Fantastic job. And
Awesome. Great.
you must need some water after all that talking. So
No, it's great. No, really. Thank you, Jeff. I really appreciate you hosting. And certainly, again, just want to mention that I really do sincerely appreciate everyone that took the time, submitted a lot of great questions. And we really do read every feedback form. We read them. So please do take
That's
the
why we're doing
time.
this.
Yes, exactly right. We want to hear what you all have to say, whether you have, constructive comments, positive comments, not so positive. It's okay. I want to hear it. We want to know whatever topics you might want to learn about as well. So, again, thank you.
Thank you, sir. And you have a wonderful evening. And we hope, and folks, if we did not address your question, it doesn't mean it was not a good question. It just means we ran out of time or it was too association specific. So, with that said, you could reach Andrew with the information or anybody at the firm. After you fill out your evaluation, your submission confirmation screen will have the contact information necessary to reach us if necessary, as well as our upcoming event calendar. So, with that said, Andrew, we're out of here, man.
Thanks, Jeff. Nice to see you.
You as
Take care.
well. Have a
Bye-bye.
nice evening, everybody. Take care and thank you for joining us. Bye now.